representation, a fundamental tenet of access to justice guaranteed under the Constitution. Additionally, the court's failure to utilize the existing mechanism for disciplining advocates as established under the Advocates Act further exacerbates the situation. For the Supreme Court to bar advocates from accessing a constitutional organ without proper dispute settlement processes reeks of judicial impunity, which the Law Society condemns at its strongest terms. In line with its mandate under Section 4 of the Law Society of Kenya Act, which includes protecting and assisting the public in all matters touching on law and justice, the Law Society of Kenya filed a constitutional petition number E026 of 2024 before the High Court. This petition challenges the Supreme Court's decision made on 18th of January 2024, as well as any resulting actions The Law Society of Kenya emphasizes its unwavering commitment to defending constitutional rights, including the right to legal representation and access to justice. So, as the petitioner in the High Court proceedings that was stayed in exchange for an expedited hearing of the civil appeal number E615 of 2024, the Law Society is deeply concerned that to date, despite the assurance and the decision of the High Court judges, no hearing date has been set for the appeal, which smacks of malice. Given the far-reaching implications of the continued existence of these orders, we urge the judiciary to expedite the resolution of this matter. The Law Society of Kenya is concerned about the precedent set by these orders, which threatens the principles of transparency, accountability, and judicial independence. Decisions of this nature risk eroding public trust in the judiciary and setting a dangerous standard that undermines the equitable administration of justice. Judicial power as a public trust must be exercised with fairness, impartiality, and inclusivity. While the judiciary must remain independent, it must also embrace constructive criticism and accountability. These qualities are critical to maintain public confidence in judicial decisions and ensure that judicial power is exercised in the service of justice and the Constitution. If our calls for the reversal of these orders are not heeded, the Law Society will be compelled to take further action, including mobilizing our members to stage peaceful protest and occupy the Supreme Court in protest. Advocates may also be called upon to boycott appearances before the court as expression of disapproval. The Supreme Court's decision to deny advocates audience borders on judicial impunity, abuse of office, and incompetence. This presents ripe grounds for removal of a judge, and we also urge the Judicial Service Commission to initiate disciplinary proceedings to safeguard the integrity of the judiciary. The Law Society remains firmly committed to promoting the rule of law, protecting constitutional rights, and fostering a judiciary that operates transparently, impartially, and in service of justice. We call on the Supreme Court to carefully reconsider the broader implications of its actions and take immediate steps to restore public confidence, which is its role to always be an impartial arbiter of justice. Because if unchecked, this conduct is slowly picking up in other courts within the judiciary, and we are worried on the trend that tomorrow if you criticize any judicial decision or you criticize any judge or magistrate, you shall be barred from going into those courts. And this also smacks of clear judicial impunity. Thank you.
Naam, karibu tena mtazamaji, tuendelee na sehemu yetu ya Shajara. Kama nilivyokuarifu hapo awali ni kwamba niko na wageni